This is former Prime Minister Malcolm Turnbull, and he's answering a question about Liberal Party mates being appointed to an important tribunal.
And I've no doubt that all the persons appointed were excellently qualified for the position that they have been selected for.
The tribunal we're talking about is the Administrative Appeals Tribunal, or the AAT. But are AAT members excellently qualified? The answer is no, and that's what this episode is all about. To get a full background, I recommend you watch episode 1 first. I'll link it in the description. But to briefly recap, the AAT is like an informal court that is supposed to independently review government decisions on a whole range of issues, like income support or veterans' entitlements. These decisions are often life-changing, so it's critical that competent and qualified people are appointed as decision makers. Turns out though, the past decade has been a race to stack as many Liberal Party mates into the tribunal as possible, with a huge proportion of ex-politicians, political staffers, and failed Liberal Party candidates appointed without any proper selection process. But it gets worse. Not only has the independence of the AAT been shredded, but so has its competence. And that's because people are appointed that are unqualified and unsuitable. This has led to a recent Senate inquiry into the AAT, and I make reference to that throughout this series. First, let's start by talking about whether people are meeting the basic requirements for the job. If someone is interested in being appointed, they have to submit an expression of interest. This is the application page, and it says that occupants of all roles at the AAT are required to demonstrate the specific competencies. These are the minimum requirements. Things like being able to apply legislation, deliver clear, concise and persuasive written decisions, and engage with information technology effectively. That last one just means you need to be able to use a computer. The problem is that many of those appointed to the AAT, especially in the last decade, completely bypassed this selection process, and that's resulted in some ridiculous situations, as some pointed out in their submissions to the Senate inquiry. One insider said that some coalition-appointed members couldn't use a computer properly and didn't know how to save a document in Microsoft Word. Other members had no relevant experience or education, or even understanding of administrative law, which is the very thing they're making decisions on. Another submission painted a grim picture. This one was written by current and former employees of the AAT. They said a newly appointed member asked who would write their decisions, as they were not competent typing or using a computer. Another member, who had been in the job for years, was unable to access the legislation they were making decisions about. They didn't know their login details for the portal used to access the legislation and policy. But this only scratches the surface. If we look at those required competencies again, there's a lot of focus on being able to analyse evidence and apply legislation, and to formulate and deliver lawful, objective and well-reasoned decisions. All of this is very aligned to someone having appropriate legal qualifications. Decision makers of the AAT, like judges, are making decisions on complex law. But you might be surprised to find out that many of those who have been appointed don't have any legal qualifications. Now, being a lawyer doesn't automatically make someone competent, but having the legal knowledge should be the bare minimum requirement. You just have to read the AAT's annual report to see that the tribunal reviews decisions under more than 400 Commonwealth laws. This includes citizenship, child support, social security, migration and refugee matters, the NDIS, taxation, veterans' entitlements, and workers' compensation. But there's a lot more, like financial services regulation, freedom of information, and security assessments by Australia's spy agency, ASIO. The point I'm trying to make is that these aren't simple matters, and getting decisions wrong can have massive consequences. Certain AAT members can also issue and review different kinds of warrants and orders. Things like temporary exclusion orders under counter-terrorism laws, search warrants, and preventative detention orders. Then there's this, the ability to issue telecommunication interception warrants, or in other words, phone taps.
You also told us that there was an AAT member who was authorised to issue warrants, but who was not enrolled as a legal practitioner. So that means that there is a member of the AAT who has no legal background who is issuing what are highly intrusive warrants. Is that correct?
So the nomination provisions and the eligibility requirements vary across different functions. And so for the issue of warrants and exercise of related powers under Part 2.5 of the Telecommunications Interception and Access Act, which is about telecommunication interceptions, the eligibility requirements are that, or include that any full-time senior member can be appointed or nominated to issue warrants under that particular part. And so that's the provision under which that particular senior member has been authorised.
Whether or not that senior member has legal qualifications.
Correct.
To put that simply, a non-legally qualified person can issue these kinds of warrants, something you would normally expect a judge to be doing. The reality is that AAT decision makers are highly paid to do a job that requires them to have a minimum legal understanding. The Senate inquiry looked into the needs for members to be properly qualified. It noted that AAT members had 3 key responsibilities: to interpret and apply relevant legislation, to conduct hearings, and to make well-reasoned decisions. The experts agree that to do these things properly, appropriate qualifications are critical. Dr. Jason Donnelly, a specialist in this field, said that members are required to consider intricate statutory provisions in Commonwealth legislation and common law principles. The New South Wales Bar Association outlined what was at stake here. A lack of experience, qualification, or skills results in poor quality of administrative decision making. This increases the risk of decisions not being the correct or preferable one. And when you think about recent scandals, it's clear just how serious those consequences can be. When matters relating to the Robodebt disaster were going through the AAT, the clear issues weren't being picked up by many of the decision makers because they didn't understand how social security law worked. Those that did got fired, but that's not what we're talking about here. The point of the AAT is to limit government overreach, and if they don't even know how the law works, they can't do that. I want to show you what actual insiders are saying about the lack of legal knowledge at the AAT. This is that submission from earlier, written by current and former AAT employees. They said that a number of members continue to struggle with concepts that are quite basic to anyone with experience in administrative law. Members also don't understand the nature and extent of the tribunal's jurisdiction. Others can't identify and locate the laws that apply to their reviews. When AAT staff try to explain issues to members, some are clearly unable to grasp why their decision is legally unsound. This lack of competence means that some members decline to take on complex matters when it becomes apparent they are not up to the task. And this is not the first time these issues have been raised.
Can you confirm that a member that there have been occasions when there have been poorly drafted decisions which are then provided to the legal team at the AAT for review?
What I can comment on is the process whereby we have an optional internal service. There are legally qualified staff there, and the members can seek advice about the correct law, including procedural requirements, and whether those have been applied. I must emphasise that staff don't provide advice or comment on the merits, facts or outcomes of the case, and it's a matter for the member whether they accept the advice on the legislation or the procedural requirements.
You have said this, and given our chairwoman has indicated she doesn't like repetition. You've said this several times. I'm interested to know, have there been occasions which the legal team has sought to review a decision by a member and suggested amendments to the decisions to ensure that those decisions will stand up to appeal?
I have no specific knowledge of that happening, but I would say it's not uncommon for a legal member of the legal team to return a decision to a member with a suggestion that they may have missed some part of the legislation or one of the criteria, and it's a matter for the member then to determine whether they wish to make any changes.
Fair enough. I'm advised the legal team will often go so far as to propose particular drafting. Can you comment on that?
Do you have a source, Senator Carr? Is it from a press article?
I have a source, and that's a matter for me to reveal. I'm putting it to you that there are members of the legal team will often go as far as proposing particular drafting.
I'd be concerned by that, and that is not the terms upon which my understanding
That's not my question. Are you aware of that?
I am not aware of that.
Are any of your members, any other members of the tribunal here today aware of that practice currently underway?
No, Senator, I'm not aware of it.
No one's aware of it. Never heard of it before. This is a revelation to you.
They've given their answer, Senator Carr.
All right. So when Mr Callaghan referred to this matter, was he referring to this practice?
I don't know what the reviewer was referring to. I can only read what's in the report.
I'm told that, well, I'll ask you, is it in fact common practice that unqualified members are producing very poorly drafted decisions which are not able to stand up in the view of the legal team to a possible challenge and had to be fixed by staff members who are legally trained?
That's been asked and answered. You've asked it, you've answered it, move on.
I'll ask you you take that on notice and ask the legal team within the AAT whether or not that event has occurred.
The written answer provided back to that question said that members can and do make requests to the legal team to review a draft decision and provide commentary on whether any legal or procedural issues arise. There seems to be this effort from within the AAT to try and compensate for the lack of knowledge of those being appointed. This is a big deal, so let's take a closer look. You might remember from the previous episode that in 2018, Christian Porter, then the Attorney General, commissioned a statutory review into the AAT. What this meant was that a former High Court judge, Ian Callanan, was tasked with reviewing how the AAT operated. In his final report, he had a ton of criticisms. When he was reviewing the structure of the AAT, he was surprised to find teams of lawyers employed to provide support to the actual decision makers, the AAT members. He found that these lawyers gave advice on issues and reviewed draft decisions to make sure there were no legal issues. They sometimes even edited draft decisions and the reasons for those decisions. The review made clear that members should not need to seek this kind of assistance. Imagine how ridiculous it is that the AAT member is going to qualified lawyers to give legal advice and edit decisions. What is their purpose then, other than to take home a massive paycheck? So just how big is this problem? How many legally unqualified people are there at the AAT? The Australia Institute, in their recent study into the AAT, looked at the appointments of political mates and their qualifications. If you remember from the previous episode, this was a study that looked at almost 1,000 appointments from 1996 through to 2022. Out of all the political appointments, the study found that 45% were legally qualified, while 47% had no legal qualifications. There was a greater proportion of unqualified people appointed. Now this is for both members and senior members, which are the two common ranks in the AAT. But it's worth drilling down even further into the data around senior members. Senior members are meant to hear more complex cases and be super experienced. They're also able to approve those warrants from earlier in the video. So you would expect all senior members to be legally qualified. But again, that's just not the case. The study found that over a quarter of political appointments of senior members had no legal qualifications. It's no wonder that reviews have found that senior members were sometimes allocated less demanding work, rather than complex cases, which would be expected given their pay grade. And by the way, the pay grade of these senior members can be around $400,000 a year. That's our public money hard at work. Now, both the Liberals and Labor have appointed non-legally qualified people to the AAT over the years, but the data shows a clear difference in how often it happened under the different parties. And almost all the senior members without legal qualifications were appointed by the coalition governments in the past decade. Now is a good time to stop and ask, how is all of this possible? How are non-legally qualified people appointed as decision makers at the AAT? Well, it's all because of a loophole in the legislation. The Administrative Appeals Tribunal Act sets out how the tribunal operates and the requirements to become a member. It says that a person must not be appointed unless the person has been enrolled as a legal practitioner for at least 5 years. That seems reasonable. But then there's a second option. A person can be appointed if, in the opinion of the Governor-General, they have special knowledge or skills. These special skills aren't defined, and the Governor-General isn't realistically going to have an opinion. They just follow what the Attorney-General says. So the reality is that this loophole is a way for governments to appoint anyone they want, with any level of experience or qualification. The AAT justifies this loophole by saying that while it is critical to have legally qualified members, it is also beneficial to have a range of expertise available in the membership. Their argument is basically that they cover a whole range of areas, so it would be good to have people experienced in those general areas. I've seen this be used as a justification a few times, but what I haven't seen is any evidence at all that there is an actual benefit to having non-legally qualified decision makers. All I've seen is big downsides. Add to that the fact that it's the government and not the AAT that controls the hiring, and so they mainly end up with people skilled in one thing, politics, not exactly the special skills that we need. The review I was talking about earlier considers this point in detail. The report clearly says that there is no necessity to appoint professionals other than lawyers to the AAT, with the one exception of accountants in the taxation and commercial division. The report makes a good point. In the court system, judges can analyse expert opinions in different fields without necessarily being an expert in that field. For example, if a judge is making a decision about medical evidence, they don't need to be a doctor themselves, because they'll be reviewing evidence given by doctors. There's no reason why the tribunal can't do the same. The report made a clear recommendation that all further appointments to the AAT should be of qualified lawyers based on merit. It said the best thing to do would be to repeal the loophole in the legislation. In other words, delete it. The coalition government, having ordered this report themselves, received the findings in 2018 and quickly actioned all the recommendations to close the loophole. That's obviously not what happened. Instead, the report was essentially ignored. But there was one person in Parliament who wasn't going to let it go: Senator Rex Patrick. In 2019, Senator Patrick introduced a motion in the Senate calling on the government to delete the loophole.
I move to matter number 83 in your name, Senator Patrick.
Thank you, Mr President. I ask that general business notice of motion number 83, standing in my name for today, relating to the Administrative Appeals Tribunal, be taken as a formal motion.
Is there any objection to this motion being taken as formal? There being none, Senator Patrick.
I move the motion, Mr President.
The motion he introduced noted that the review into the AAT had said that repealing the Special Skills Clause was desirable, and it called on the federal government to urgently act to repeal it. The coalition government, who was in power at the time, had this to say.
Thank you, Mr President. The Government is considering the recommendations of the Honourable Ian Callanan, ACQC. The consideration of Mr Callanan's recommendations to limit members to lawyers will be considered in the context of the AAT's role to provide merits review, and that is low cost and informal. This includes having large numbers of current members without legal backgrounds but with expertise from across a diverse range of matters considered by the AAT. The Government will continue to ensure that all members are appropriately qualified and appointed on merit.
They never considered the recommendations, and this was all fluff, which isn't all that surprising. But what was surprising was Labor's response.
Labor will not support this motion that would prohibit non-lawyers from being appointed to the AAT. There are some non-lawyers who have the skills and experience to make them excellent AAT members. However, there is no doubt that the Liberal government has grossly misused the AAT as a Liberal Party employment agency.
She then went on to raise issues about all the political appointments being made by the coalition. I don't understand why you wouldn't want to close off this loophole. It won't solve the problem of political appointments completely, but it will limit them. The Senate then voted on Rex Patrick's motion. In support were the Greens and Independents Jackie Lambie and Sterling Griff. Voting against the motion in a clear majority were the Coalition, Labor and One Nation, and so the motion failed. But Rex Patrick didn't give up. In 2021, amendments were being passed in Parliament that related to courts and tribunals. You would have thought this would be the perfect time to improve the AAT and put in place recommendations from all the inquiries that had happened. but there was none of that. Rex Patrick put forward an amendment of his own to again try and close the loophole allowing non-lawyers to be appointed.
Senator Patrick, I believe you are seeking the call in the second reading debate.
Thank you, Mr Acting Deputy President. I'm pleased to speak today on the Courts and Tribunals Legislation Amendment 2021 Measures Number 1, Bill 2021. My particular focus is on the Administrative Appeals Tribunal. Most citizens pay little attention to matters relating to the AAT until they're confronted with an administrative decision they feel is incorrect. Section 7 of the AAT Act provides for appointments of members that, in the opinion of the Governor-General, have special knowledge or skills relevant to the duties of a senior member or member. That special knowledge shouldn't be the phone number of the Attorney General, whose advice the Governor-General must follow. In a 2018 statutory review of the AAT conducted by former High Court Justice Ian Callanan, ACQC, Justice Callanan recommended amending Section 7, stating, and I quote, "There is, in my opinion, no necessity to appoint professionals other than lawyers to the AAT, except perhaps for accountants to the Taxation and Commercial Division. My own experience in the AAT, which is extensive, strongly supports that recommendation. While the AAT is not a court, legal knowledge, training and experience is essential for rigorous review of government decisions and to ensure the integrity of the process." So I'll be moving an amendment to modify Section 7 of the AAT Act in accordance with Justice Callanan's recommendation. I would hope that there will be support from the Labor opposition. After all, Labor has made a big deal about these political appointments, though in August 2019 the opposition refused to support a Senate motion moved by myself calling on the government to alter Section 7. Unfortunately, I understand that the Labor Shadow Attorney General Mark Dreyfus has directed that Labor will oppose my proposed amendment. Labor says that legal or accounting qualifications won't stop all political appointments. Well, that's true, but most of the mates appointees of the Liberal Party are not former legal practitioners, and so the amendment that requires a person to have a legal practitioner's qualification for at least 5 years would clearly go a long way to stopping this appointment corruption. The amendment will radically narrow the field and ensure that appointments have a baseline of professional qualification and training highly relevant to the work of the AAT, which, one should emphasise, can be subject to review by higher courts. That would go a long way to restoring public confidence in the integrity, impartiality and the competence of the AAT.
You could hear him appealing to Labor to support him on this. Of course, the coalition would never back it, but like before, there was no support from Labor either.
Labor does not support this amendment. Senator Patrick has argued that this amendment would ban political appointments, but that is simply not the case. It would simply limit the Liberals to appointing mates who have law degrees. Indeed, many of the Liberal mates the government has appointed to the tribunal have been lawyers.
I have to quickly jump in and correct some key things that he said there. The requirements aren't that you need a law degree, but rather to be a qualified lawyer for 5 years. It's not a low bar. And while it's true that this won't stop political appointments completely, Senator Patrick was never arguing that it would. He was just saying that it would be an improvement on the current situation. And while many Liberal appointments have been lawyers, the majority of political appointments haven't been. In the end, the only recorded support for the amendment came from the Greens.
Senator Seward.
Thank you. Could you please record the Greens' support for this amendment?
The coalition didn't even bother saying anything. They just opposed the amendment, and it failed.
The question is that the amendments be agreed to. Those of that opinion say aye. Against say no. The noes have it.
For the sake of balance, I'll mention that there have been some experts that have said that it can be beneficial to have diverse experience amongst AAT members. And both the statutory review and Senator Patrick's amendments accounted for that by saying that members hearing matters to do with, say, taxation can be accountants.
Now, there is a legitimate and important debate that we could have about whether the AAT should be more like a court in terms of who sits on it. Perhaps the tribunal should, as Senator Patrick suggests, be made up of only lawyers, or perhaps the Parliament should say that 90% of tribunal members must be lawyers, or that certain divisions of the AAT should only be made up of lawyers, whereas other divisions could have greater diversity. These are legitimate questions, but they are weighty ones.
Maybe there's more discussion needed to get the balance right. But no one is having that discussion, and it's time we figure it out. In an unfortunate note, Rex Patrick wasn't re-elected in the 2022 federal election. Kim Carr, who headed up the Senate inquiry into the AAT, also retired before the election when it became clear he wasn't going to be pre-selected again by Labor. So with all that, we'll have to wait and see what Labor does with their promised review of the AAT. Will they close this loophole? It's hard to tell at this stage. But something needs to be done. This is the state of the AAT today. Overrun with political appointments, no clear rules around qualifications, and no proper selection process to actually make sure people have the required competencies. All of this strengthens the recommendation made by the Senate inquiry to scrap the whole thing and start again. But even though the AAT is completely compromised, luckily there's a body called the Administrative Review Council, or ARC. This is a group of experts that provide best practice guidelines on administrative law, protecting us from massive government failings, or that would have been the case had the coalition government not unlawfully defunded it. And that's the next episode of this series. Thanks for watching. If you want to support the channel and help me make more content, please consider checking out my Patreon page. Link is in the description below.